So, what happens when the Supreme Court hands down a judgment that seems to fly in the face of the plain text of the Constitution? That's exactly what we're diving into today, with a really deep look at Professor P.K. Tripathi's incredible critique of the landmark Hoist Pharmaceuticals case. We are going to break down, piece by piece, how the court interpreted Article 254, the article that's supposed to sort out conflicts between union and state laws. Now, if you're a law student, getting your head around this debate is absolutely crucial. It's really a masterclass in constitutional interpretation, legal reasoning, and the very boundaries of judicial power.
Okay, so here's our game plan. First, we're going to start with the specific ruling in the Hobbs case, the thing that kicked off this whole controversy. Then we'll unpack Professor Tripathi's central argument and see how he claims the court totally misapplied the doctrine of pith and substance. From there, we'll follow his logic as he re-examines the very precedents the court used, clarifies the huge difference between a legislative overlap and a true legal conflict, and then finally, he brings it all home by going back to what he argues is the plain, undeniable meaning of the Constitution's text. All right, before we get into the weeds of the conflict, let's just do a quick reset on the basic framework. As you know, in India's federal structure, legislative power is split up. Parliament has exclusive domain over the union list, state legislatures get the state list, and then there's the concurrent list, where they can both make laws. This division of power is the whole reason Article 254 even exists. It's meant to be the referee when laws from these different lists inevitably clash.
Okay, let's get right to it. What was the specific problem in the Hoist interpretation that set off this whole firestorm? This right here, this quote from the Hoist judgment, is the heart of the entire controversy. The Supreme Court said that for a repugnancy, a direct conflict, to even be considered, both the union law and the state law had to be about a subject on the concurrent list. That one sentence effectively put a huge fence around Article 254, dramatically shrinking when a state law could even be challenged, and it's this very restriction that Professor Tripathi takes issue with.
Right, and just to be super clear, repugnancy is the Constitution's built-in conflict resolution tool. Article 254 basically says, when a valid state law and a valid union law are in a head-to-head contradiction, the union law is going to win. The part of the state law that conflicts is rendered void. Simple enough, right? But the massive question that Hoist raised was, when do we even get to apply this rule?
And the court's very narrow answer to that question leads us directly to Professor Tripathi's powerful central argument. He does not mince words. He calls the court's decision a violent departure from the plain meaning of the text. He's not just suggesting a minor error in reasoning, he's basically accusing the court of ignoring what the Constitution clearly says.
So what's he really saying? His core thesis is that the court essentially took a red pen to the Constitution. By saying the repugnancy test only applies when both laws come from the concurrent list, the court, in his view, just made up a rule. It added a limitation, words and conditions, that simply do not exist in the actual text of Article 254.
Now, to really grasp his critique, we have to look at a key legal tool, a doctrine that Tripathi argues the Hoist Court completely misused, and that's the doctrine of pith and substance.
Now, this doctrine is a classic in federal systems like ours. It's a way of asking, what is this law really about? What's its true nature and character? Its main job is to figure out if a legislature had the power, the competence, to make the law in the first place under Article 246. So if a state makes a law that's really about something on the state list, but it happens to just incidentally touch on a union list topic, this doctrine prevents the law from being struck down. It keeps the three lists from becoming these totally rigid, don't-cross-the-line silos. And this slide just lays out the disagreement so perfectly. On the left, you've got the Hoist Court's approach. They used pith and substance almost like a shield to avoid a repugnancy test. They said, well, since this law is in substance a state matter, it can't be repugnant to a union law. But look at Tripathi's view on the right. He says, no. Pith and substance is just a gatekeeper. Its only job is to ask, did the legislature have the power to make this law? If the answer is yes, its job is over. The next, totally separate question, does this valid law now conflict with another valid law? That's a job for Article 254. They are two different tools for two completely different jobs.
And Tripathi doesn't just pull this out of thin air. He builds his case like a prosecutor, going back to the foundational judgments the Hoist Court itself used as its foundation, and he shows how they were misread. Let's dig into two huge examples.
First up, he takes apart the famous judgment from Chief Justice Squire in the federal court. This case was a cornerstone of the Hoist Court's reasoning, so it's a critical piece of the puzzle.
So here's the key takeaway. Chief Justice Squire was focused on one thing and one thing only: legislative competence. Did the Madras legislature actually have the power to pass this law? He used pith and substance and said, yep, it's really about money lending, so it's valid. But, and this is the crucial part, he went out of his way to say he was not going to decide the question of repugnancy. Tripathi's point is devastatingly simple. The Hoist Court took a judgment about power and mistakenly treated it as a judgment about conflict.
Next, Tripathi turns his sharp legal mind to the Privy Council's decision in the Bengal moneylenders case, which dealt with a very similar situation.
And would you believe it? We see the exact same pattern here. The Privy Council looked at the Bengal law, said its pith and substance was money lending, and declared it validly enacted, or intra vires, and that's where the judgment stopped. They never went to that second step of asking if this valid law was now repugnant to some federal law. So both of these key precedents were only about competence, not conflict. And according to Tripathi, this means the Hoist Court built its entire theory on a fundamental misreading of legal history.
Okay, so this brings us to what Tripathi sees as the central procedural error in the Heist judgment, the court blurring two completely distinct constitutional tests into one.
As Tripathi puts it, the court just got them all mixed up. It confused the normal phenomenon of overlapping, which happens all the time in a federal system and is what pith and substance is for, with the much more serious and distinct legal issue of repugnancy, which is about an actual, direct collision between two valid laws.
Now this slide is absolutely key because it lays out what Tripathi says is the correct way to do this. It is a very logical two-step process. Step 1, you test for validity. Is this law even within the state's power to make under Article 246? That's when you use pith and substance. If the answer is no, the law is void. Game over. But if the answer is yes, then and only then do you move to step 2. You pull out Article 254 and see if that valid law is repugnant to a union law. It's like a security check. Pith and substance is just checking your ID at the door to see if you're allowed in. Article 254 is checking if you're bringing something inside that breaks the rules. Tripathi argues the Hoist Court just smushed these two separate checks together and created a totally flawed legal test.
So after deconstructing the court's entire reasoning, what's the right answer? Well, Tripathi says the answer isn't buried in some complex doctrine or a misreading of old cases. It's been right there in front of us the whole time, in the plain words of the Constitution itself.
The very title of his famous paper on this is "The Text is Explicit." And that's not just a clever title, it's his entire argument in a nutshell. He tells us to go back to the source, to the actual words of Article 254, and he argues that the meaning is crystal clear and doesn't require any fancy judicial interpretation.
And when you actually stop and read the text, as we have it here, his point is incredibly powerful. Just look at the wording. It talks about a conflict between a law made by the legislature of a state, it doesn't say a law only from the concurrent list, and a law made by Parliament, which Parliament is competent to enact. Again, any valid law, whether it's from the union list or the concurrent list. The only place the concurrent list is specifically mentioned is for a separate category, an existing law. Tripathi's argument is that the framers of the Constitution chose this broad, sweeping language on purpose. So for the court to come along later and say it only applies to the concurrent list was, in his view, an act of making law, not interpreting it. And Tripathi's meticulous analysis really leaves us with this final, profound question that goes to the very heart of how we think about our Constitution. When the text is explicit, when it's plain as day, what could possibly justify a court departing from that plain meaning? It's a question that forces us all to think about the proper role of a judge when faced with the clear words of the document that governs the entire nation.